Welcome back from the break. My name's Kathy Chiou. I'm at the University of Nebraska-Lincoln, and I have the pleasure of introducing our next speaker, Susan Griffith. Susan Griffith is an attorney with 37 years of experience, working with domestic violence cases. Susan is the director of the Family Law Clinic and the Domestic Violence Intervention Clinic at Brigham Young University's J. Reuben Clark Law School, where she has been teaching since 1995. She has served as the founding executive director of the Timpanogos Legal Center, often referred to as the TLC, since its creation in 2010. TLC is known for its innovative approach in providing services to those who cannot afford an attorney and must represent themselves in court. Last year, TLC provided almost 8,000 services to clients throughout Utah. About 2/3 of TLC's time is dedicated to clients who are survivors of family violence or sexual assault. Thank you so much for joining us today, Susan.
Thank you so much. And I'm very happy to be here today. I'm just going to share my screen as we switch that over. Is that appearing correctly for everyone else?
Yes, looks good.
Great. Okay. So I don't know how many attorneys you have in this area, but I suppose that maybe I'm not talking to a group of attorneys. I'm talking to those of you that are working in that area of research on traumatic brain injuries and those that are trying to help people who are navigating those issues. And I'm sure that those of you who have worked with clients have heard the horrible stories they have to tell about the difficulties they faced as they have tried to navigate the court system. So today we're going to talk about why it's so difficult for victims to navigate the court system and what we can do to make it better. So starting out, let's see if I can get. Sorry, there we go. So what we're going to cover are the challenges that people with traumatic brain injuries face in court proceedings, the importance of educating the judiciary and the bar. And the reason that's important to all of you is we need you to help us do that. And then finally, things that we can do to accommodate people who have TBIs or even more mild brain injuries when they have to go to court. And so that will be our lineup. But we're starting out first by talking about the actual challenges that are faced by people with brain injuries who are going to be looking at going into court proceedings. And most people have heard the horrendous stories. I don't know anyone who's like, I was just subpoenaed to go to court, and that sounds great. No one enjoys that experience. But you can imagine, particularly for a person who has issues related to TBIs where they're dealing with memory loss, they're dealing with feeling like they have disorganized thoughts. It's hard to communicate. Even for someone who's an expert witness, who's trained on how to present in court, it can get your heart racing and it can create those kinds of things. So imagine for a person who's feeling not confident going into that situation. So let's talk about why it's particularly daunting for people with brain injuries who are experiencing this. One of the things that most people don't understand, even attorneys often fail to realize this, is that a victim of domestic violence isn't facing one court proceeding. They're usually facing multiple proceedings. And those multiple proceedings all have different people involved in it, different standards of proof that have to be met in order to get what they want out of that proceeding. They require different things of the victim. The victim plays different roles. Sometimes it's witness, sometimes it's as the petitioner, sometimes it's as the respondent. It can be lots of different ways. So we're going to talk about that. So obviously the first one is criminal proceedings. The victim has the person with the brain injury may be the victim of the crime, and that testimony is needed in the criminal case. Then let's say that their child was present during the time that he or she received that injury. If a child was present, typically, or at least in the United States, you're going to have the Division of Child and Family Services, or whatever your local agency is called, they are going to come and investigate what was the impact on the child. Is the child in danger? And you can imagine for someone who's just been through this horrendous event, the idea of now you've got someone coming in who's looking at, is this child safe? And now you're worried about, am I going to lose custody of my children on top of what's just happened? Very, very frightening for the person who has just gone through this ordeal. Then you often have the family law consequences. If they were married, there might be divorce proceedings filed. If they weren't married, but they had a child together, there may be custody actions that happen. And there's nothing that's going to frighten a person who's been through this more than the thought of, how is this going to impact my child? How am I going to be able to show to the courts that I am the parent that should be able to take care of this child, even at this very time that I might be suffering the greatest effects of the brain injury? Then you have the protective orders. And every state, I should start out by saying every state in the United States has different family law laws. And they're very state specific. And then we add, this is, I know, is an international conference. So you add those layers on top of that. So it's important to understand the proceedings. I'm using Utah as the basis for that because that's where I am practicing. But the things that we're talking about are going to probably be generally true in your area, although they may apply in different specific ways depending on how your laws are written and how your procedures work. In Utah, there are multiple types of protective orders. In other places, for example, in California, they have one type of petition, and then you can fill it out, and it will take you down to whether you qualify or not. In Utah, you have to file for the right type of protective order depending on the circumstances around it, which can make that also more complicated. We have them in the criminal. We have protective orders out of the criminal system. We have them civilly as well, and we have stalking injunctions. We have child protective orders if the kids were at risk, sexual violence, dating violence, and workplace violence. So there's many different kinds of protective order proceedings as well. Then this is much less rare that victims will seek this out right away, but it's also possible there could be a personal injury case, or what we call a tort case, where they're suing the person who's caused the damage. Typically, attorneys won't take those cases because those personal injury attorneys are looking for where there is insurance money who will provide the payout. So they like automobile cases where they can go after the insurance carrier for the person who caused the accident. When it's an intentional tort, someone who committed a crime against another person, there's no insurance pocket for that. But there are increasingly more attorneys who are looking where there's assets at being willing to take those types of cases. So there could be that kind of case as well. And then finally, disability cases. If the injury caused the person to actually become permanently disabled, they may need to be seeking through administrative processes the ability to get benefits, public benefits, in order to help support them and their children. So look at that. Out of maybe one instance where a brain injury resulted, you could end up with potentially 6 or more kinds of cases resulting from that. And all of them have different things that need to be proven to the court. All of them some have prosecutors, some do not. Some have guardian ad litems to protect the children, some do not. Some have victim advocates involved, some do not. And it's very, very confusing for the victim who's told something by the prosecutor, and that person's going to think that applies in general to the court system. They don't understand, no, it only applies to this one place. So you can understand, even for a person who doesn't have a TBI, This is daunting. This is a daunting system to work through. You're working through so many different places. It's possible that you could have a different judge for every single one of these kinds of proceedings. The requirements are different, and that would feel overwhelming for a person, even a person experienced in a court setting. But most of the time, when I talk to victims, they haven't even had a traffic ticket before. They've never been in even the most fundamental levels of the court system before, and now facing multiple proceedings that are very complex and have so many different moving parts to it, it just feels absolutely overwhelming. And how can we expect someone who's just gone through the terrible experience they have with the physical consequences that are being suffered to be able to navigate all of this at the same time? So now you can understand more about why it's a bad situation. No one looks forward to having to go to court for any reason. But for somebody who has suffered, for a victim who has suffered a traumatic brain injury, that is completely overwhelming. On top of that, the challenge is that the challenges inside of each one of those proceedings depend on the type of court case it is. So I want to give you an example of how that could play out. This is just a really brief hypothetical, but you can see why the different types of proceedings even play against the person with the traumatic brain injury. So we're going to say woman has a child with a wealthy man. He is physically abusive during the relationship. He has strangled her on several occasions. Last time, he knocked her head against the wall before wrapping his hands around her neck. She came from a family where her father had physically abused her as a child, and she had a high school boyfriend who beat her so severely she was hospitalized for a week. So, simple background case. Now, let's look at how that fact situation would play out in these three different types of cases. And we're actually going to start on this side of the page first, looking at the criminal law case. So, the first thing is, in order to prosecute a case, the prosecutor needs to have enough evidence that he knows that if this case goes to trial, he would be able to convince a jury beyond a reasonable doubt that the person that they had named as the perpetrator was in fact the person who did it and who caused that harm, right? And so to have that happen, in this case, women's testimony must be reliable. The prosecutor needs to think that the jury is going to believe the woman's testimony. Well, if this case goes through in the next, usually that will be at trial within a year. And if she's still suffering memory loss and confusion and can't remember clearly dates or even what happened. So many of the clients I talk to will give very general, well, I remember we were arguing. I remember he backed me up against the wall. And the next thing I remember is I woke up on the floor. And they don't even know how much time happened between that or what it is that happened, what it is that he did in that amount of time. And sometimes the reason for that memory loss is trauma. Sometimes it's the brain injury, but the reality is that actually doesn't even matter in this case because what the prosecutor needs is, regardless of what happened, I need someone who can say, this is who did it, and this is how it happened, and this is what the consequence was. And who's going to be able to say that if there aren't any other witnesses that are present, which so often, especially in cases of family violence, it might be very young children, or it might be no one at all who was present except for the perpetrator and the person who suffered the violence. So you can see why that is so difficult. The victim's testimony may be excluded because it is deemed unreliable, or at the very minimum, even if they can testify, it might be called into question as to what the person really truly remembers. And that can be very, very difficult. And now add on top of that, she's had that visit from the Department of Child Services who's looking at, are you capable of taking care of these kids? And if she's telling the prosecutor, yes, since this incident, I haven't been able to think clearly. I can't remember things. I can't. Okay, now if DCFS finds this out, what are they going to do? Is there a possibility they're going to take the kids into custody because of the, of the effects that the victim has suffered as a result of this? And so sometimes the person becomes very uncooperative with the prosecutor because they don't want to tell them how bad the effects have been. You can see the tension between those two different cases and why the victim would be in such a quandary about even what they should do. How should they proceed? What should they tell? And who should they tell? Where is it safe to say what's really been happening to them inside of the court system? And the reality is, it really isn't safe because anything that is said that's taken as testimony in one court can be used in another court. And that makes it really difficult for the victim. So now let's just go over here and look at how it's different in the tort case or the personal injury case. And the first thing to understand is a prosecutor is always going to tell them, don't file that kind of case, even if you can find an attorney who would do it, because in the criminal case, the perpetrator is going to turn it around and say, this person is just looking for money. They just really want my money. We weren't married in this situation, so this person isn't going to get alimony or get any property division. She's just looking for a way to extract whatever money she can from me. So she's lying about what happened. She's always been a hot mess, and now this is all just a scheme to be able to get money from me. So you can see how those systems get pitted against each other as well. And the person who suffered the harm from it gets really caught between those. Now let's enter the family law system. And in the family law system, the judge doesn't have to decide really who committed the violence or what happened. They're looking for what's in the best interests of the child. So if dad goes in there, assuming it's man here who has committed the violence and he's the father of the child, and he's saying, you know what, there was a little incident, it got a little out of hand. I did not cause that damage. That damage was caused by boyfriend and father from a long time ago, and she has always had problems with her memory and with her functioning, and I've just tried to support her and help her through it. And yeah, there was a little incident, but none of that bad stuff happened for me. But I'm getting treatment and I'm getting counseling and I'm really dealing with my issues, and I'm the person who's stable and I'm the person you can trust to take care of the kids, because right now she can't remember what day it is, and she doesn't remember to feed the child, and she doesn't remember, to get the child to school on time. But I can do all of that. It's safe to put the child with me. And now all of a sudden you look at a person who's been through this horrible ordeal and they're looking at, if I don't lose custody of the child, how much access is the perpetrator going to have to the child? And can that person really look like they're a more competent parent than I look at the time to the court? And you can see how the level of anxiety that's normal for them to already be feeling as a result of the combined trauma and result of the traumatic brain injury, and now going into this hotbed of court proceedings, it's just an impossible situation for them to really function throughout that. And you can see why so often wrong outcomes happen in these cases because of the way the court proceedings work. So I'm painting a pretty bleak picture because it is so difficult for the clients who are going through this. So hopefully this is helping you to understand that when clients say, I'm afraid of going to court, or that's not just like everybody's afraid, or that it's a bad experience like it is for a normal person who's going through a divorce case or some other type of criminal case. This is really daunting. They are having these experiences where what's said in one court can be used against them in another court proceeding, and they're suffering the effects of the abuse on top of having all of these court proceedings happening, many of them simultaneously or close to each other. Now, one of the things to understand is the courts need proof and that can be a real challenge. How do we make that invisible injury of the brain injury visible to the court? TBIs don't always show visible signs on standard imaging, and judges and jurors like proof. Preferably something that's visible to them, it's tangible, things that can be corroborated, meaning the story makes sense. All of the pieces fit together. And sometimes it just doesn't come in that neat, natural package. So how can we make those TBIs visible for courts to give them that proof that they need? We should all be encouraging thorough testing as soon after the injury as possible. That starts with getting law enforcement to recommend it, or first responders to recommend getting those the tests. And so often they will go in just for an emergency room exam, but they won't have the appropriate neurological evaluation that's really needed to diagnose the TBI. So, using experts in court where possible makes a huge difference in the outcomes of cases. But if you're talking about a family law case or a lower level domestic violence case in a criminal court, prosecutors would never be able to hire experts to be able to do that in those cases. So that becomes a real barrier to getting the understanding, the basis for jurors to understand how important these cases are and what's happening. And then the other thing is it takes a lot of time as an attorney to really prepare the client for the testimony that you're going to need to elicit for them. And a lot of family law attorneys are working off of a volume business where, they allot a certain amount of time for trial prep, and it might take many more hours to prepare someone who's been a victim of traumatic brain injury. And even then, you're not for sure that they really are going to be prepared and going to be able to function at the level that you need them to on the day that they're testifying. So you can see why it's so challenging. The other kinds of things, look at how some of the common impairments that result from TBIs and how those things get interpreted in court. If the person is struggling with communication, the words aren't coming clearly, they're not flowing, that makes them look uncertain or maybe untrustworthy. People that have memory loss, that may even block their testimony completely. How about the impaired executive function, which contains so many things, but if they can't focus, if they can't sustain attention, organize their thoughts, they're coming across as scattered and not believable. Sometimes police think that the person is just not going to cooperate with them. And it's not that the person's unwilling to cooperate, it's because they're struggling to understand and they're struggling to communicate. Or they may actually have physical speech difficulties as a result of the injuries that they've received. And so all of these things, you can see how badly this comes across in a court setting, when really, if you can explain that this is a natural result of the violence that they have sustained during the event that is in question. Let's talk about the impact really quickly of pre-existing conditions, because that is very difficult. In a lot of these court cases, you have to be able to show that the incident that you're talking about is what caused the damage. And in the hypo I gave you, there were other places where injury could have occurred, or it could have been that the person was in a car accident before. So now the perpetrator is saying the effects that victim is experiencing is not the result of my action, it's the result of the car accident. She's never been the same, or he's never been the same since that car accident happened. And in court, causation is a huge element to prove what caused the injury. And sometimes that is really hard to narrow down in these cases. So now let's move really quickly to the importance of educating the judiciary and the bar. experts on TBIs are needed. We need you to help us. We need to do more training for attorneys through what we call continuing legal education events and other types of conferences. They need to understand. Now, typically, the attorneys who do understand it are the personal injury attorneys, the ones that are seeing TBIs as a result of car accidents or workplace injuries, those kinds of things. But family law attorneys and criminal attorneys are often not trained in those areas to identify it. So we need to do better at getting information across the spectrum of the attorneys who are seeing these types of cases. We need mandatory training for the judiciary, including justice court judges or the judges that see those very kind of the low level domestic violence cases, which often erupt into the higher level. We need all of our courts understanding the impact of brain injury so that they can understand why someone may be coming across untruthful and whether that evidence really has to be excluded or whether there can be things that can be put into place that can allow the victim to be able to testify more comfortably in a situation where they are given more time and there's like understanding on why they're not going to be able to just respond to every question quickly like that. We need collaboration between fields. Attorneys need to understand what you all understand as the researchers, as the people who are providing the medical treatment, the psychological treatment, the supportive services that are necessary for a person who has suffered a TBI. And we need those experts on individual cases. We need it on the policy level and the collaboration level, but we also need it on those individual cases that are happening. And once again, that's expensive. Who's going to do that? It would be wonderful if we could find a way that we could get panels of experts who are willing to donate time, sort of like attorneys sometimes take pro bono cases. If we could get some people who could get expert testimony in, what I have found is that when you train a judge even on one case through an expert to understand what it is, the next case that comes in, they're going to have that knowledge and they're going to have that understanding, and they will apply that even in future cases, even if it isn't on the record the same way that it is in the original case. And then we need to do more policy education for both legislators and funders and researchers and educators across the spectrum so that we're working in collaboration on how to deal with these issues. Let's talk about how people can be accommodated when they have a traumatic brain injury and they have to come into the court setting, because there are a few things that we can do that will help people feel a little bit more comfortable in the courtroom. The first one is to reduce distractions. The other pictures of courtrooms I've had up here have been kind of more formal. This is more like what a justice court might look like. It might look like more of a bare basic room. I liked it when I found this picture. There's a fan there. Imagine the person with a traumatic brain injury who's hearing the whirring of the fan, and that becomes a focus and a distraction, and it's hard to even hear the questions or to be able to focus on what's saying. Or look at the situational room. You have the door to the hallway right where the victim would be sitting. If I were the attorney, I would ask to move that chair over here and to close the door so we didn't have those kinds of distractions or noise or other things that could just add to the difficulty for that person of sitting, sometimes for a long time on the stand, being asked questions both by the attorney who's either representing the person or the prosecutor who's trying to get the conviction against the perpetrator. But then on top of that, you have to go through the questioning or the cross-examination by the other attorney as well. One of the most common complaints I hear from clients who have to appear in court is it's about the lighting. The lighting in the courtroom often it's very bright, and if you've had a traumatic brain injury, that can be really, really difficult, and that can make the symptoms much more difficult to bear when they're in that high stress situation. So a lot of times just arranging a way to only turn on half the amount of lights, or to be able to reduce the amount of lighting in the courtroom, making that possible. That's once again another area where education for judges and for administrative office of the courts, where they can make the environment of the room more friendly for someone who has sustained that injury. The ability to control the noise, considering that seating arrangement, like I mentioned before, providing extra breaks, like letting the judge know ahead of time that we may have to call frequent breaks to allow the person who has to testify time to be able to maybe get a drink of water, to be able to breathe, to be able to whatever, so that they can continue to focus and come back and be able to testify and tell their story and describe what's happened. But usually those things are, you're going to have to arrange those things ahead of time. You can't just do it on the spur of the moment. So that goes back to the attorneys need the training on how to do that, how to set up asking for that successfully, and then getting receptive court personnel who are willing to make those kinds of adjustments to help the client, to help the people who have to be the witness in those cases be able to do so successfully. Lastly, I just want to talk about the things an attorney can do to help make the situation better for the person who has to appear in court. The first thing is to use really simple and direct questions. A lot of times as attorneys, we know the flow. We want to establish some basic facts about the case, so we tend to ask multiple, on this date at this time you were in this place. That's really three things. And if the person is like, what was the date? What was, that can throw them off right from the very beginning. So it's important to go more slowly, to keep each piece separate and distinct so that the person is understanding and can get into the groove of responding to those things in a comfortable way without immediately feeling overwhelmed by the number of things that they are responding to. The attorney that's either representing the person or the prosecutor, who should be trying to protect their witness, can use objections to request rephrasing when the other side is cross-examining the witness. So for example, it's also common for a defense attorney to get up and say, isn't it true that you, and then a long statement, and the person may be, well, this part was true, but that part wasn't true. But how are they going to have that ability to be able to really communicate that effectively? And so the attorney can raise the objection of, for multiple questions, which in a lot of cases, normally you'd let that slide because it moves things along more quickly. But for a person with a traumatic brain injury, you need to slow that process down, let them be able to think, give them the time that they need to be able to respond. So there's things as we can do as attorneys to help protect the person who's testifying and to help them be able to respond appropriately and to give the testimony that they need. The other tool that can be used is what we call a motion in limine. It's a pretrial request that you send to the court. You have to give notice to the other side saying, I want this testimony to come in, and I know that's going to be questionable. I want a ruling on that before we ever actually step in for trial or to take testimony on this. And you also can ask to have evidence excluded. So for example, you're probably familiar with, when you have a victim of sexual assault, you don't want her sexual history to come in. So you do a motion in limine to suppress that. And you would know whether you've won or lost that before you start the proceeding. Similarly, you have a client who maybe really can't track dates, but actually can testify pretty well about what happened. If you know that, but you need the client to introduce the date, you may want to do a motion in limine to allow the client to use a calendar that she kept, for example, that had on there the date that the thing happened, and you make that motion to say, I need this to come in so that when I ask the client can refer to the calendar, explain what the calendar is, and we can be able to identify that piece of evidence that's necessary for that case. But you don't want to get into the court proceeding and find out they're going to exclude that piece of evidence that would be the thing that would help your client be able to give the testimony that they need. So there's some things that are some extra levels of work, but it will actually really work for the client. And then just understanding as the attorney, you need to plan on having extended prep time to help that witness before the hearing, that they're going to have a lot of questions. They're going to need to understand what it's going to be like in that courtroom, taking them to the courtroom and helping them get acclimated to what it's going to be like, where they're going to sit. That preparation can help alleviate at least some of the anxiety that they have about attending. So I know that was a lot all at once. Hopefully, there's ideas in there, as you know, as you're working with people who are going to be facing court proceedings, understanding just how they are often in a catch-22 in terms of the multiple proceedings that are happening around them, and then also helping them understand or telling them to ask the prosecutor they're working with or to ask the attorney who's representing them about some of these things that I've mentioned today, to see if there's ways that they can be better prepared to go through the court experience. All right, I am happy to take questions if anyone has them.
Yes. Thank you so much, Susan. Such an informative talk. And I love the concrete, just practical tips that you had for us to be able to help survivors in the situation. We do have some questions in the Q&A. So the first one is, how impactful is the documentation of a forensic SANE nurse in the court proceedings to support the individual with IPV brain injury?
The answer to that is it's going to depend on how it's used. It's going to depend on what the information is that the SANE nurse has. It's going to depend on the SANE nurse's ability to be able to testify. Some are trained well on how to do that, and that in combination with how well prepared the attorney is to handle the objections that are going to come, and to be able to get that testimony onto the record. So in some ways it can be, in some cases it's going to be very powerful and very useful. In other times, some of it's going to get, maybe even you're going to get that pre-trial where, no, we can't even use this. And so it is going to depend from case to case. It will be different.
Got it. A little bit tricky there, it sounds
It
like.
is tricky. Hard to, and that makes
Um,
it hard to predict. And here you have a person who's gone through memory loss, and they've gone through, the physical just all of the different difficult things that they have to go through in trying to recover. And then they're trying to grasp, well, what's going to happen in court? And so many of those answers are going to be, well, it depends. It depends on
yeah.
how well this testimony goes. It depends on how well this piece goes. And boy, that just can give them such a feeling of uncertainty, which heightens all of
Right.
the other challenges.
Yeah, I can imagine. Some other questions that came through. So this attendee I understand that the proof of TBI could be helpful in criminal cases, but it can be used against the victim in family court. So how do we but can it be used against the victim in family court, right? So I think you were talking about potentially something that's evidence in one case could be used against you in another, and how do we balance that then, right?
Right. Well, so it's really difficult. And the thing that's super difficult about it is the family law attorney never talks to the prosecutor. They don't talk to each other. The prosecutor cares about getting their case, a victory on their case. The family law attorney is trying to get, to get what the client wants in terms of custody, and then the property division for that client. And so working out how you're going to use that. Now, there are a lot of things that you can do. I you know, you need to be able to use the evidence you have. And so, I would say you want that evidence to be used in the criminal case of how bad the damages were to the client, and the problems that that has created for them. But at the same time, you'd better be ready in the family law case to say, here's the support we've put around the person who has suffered this that will allow them to still continue to care adequately for the child. And you should certainly not put the child in the custody of the person who has caused these problems. But once again, the causation of it often is in question. So it takes a lot of skill. And a lot of times family law attorneys are very focused on, I know how to handle financial issues. I know the basics of, how to argue custody cases. But traumatic brain injury cases are different. You have a person who's usually sustaining long-term consequences as a result of what they've gone through, and it is going to impact their parenting. And so how do you navigate what is the right thing to happen here? For the family law court, it's what's in the best interest of the child. And that doesn't always mean, hey, the person who caused that trauma, they should be punished. That's in criminal court, not in family law court. In family law court, we're all about what's the right thing for the child. So I think it's on the practitioner to really build up the case for why the person with the traumatic brain injury is still in a position to be able to care for the children effectively. What are the supports around them that are going to allow them to do that? Because the judge isn't going to want to reward the perpetrator with custody, but sometimes if it's not certain who really caused the injury or how bad the injury was, and that person, it's amazing to me how perpetrators can come across so polished and so charismatic, and so they can talk the talk and say all of the right things when they're in court. And, especially if the person who suffered the traumatic brain injury cannot, you have to be honest, that's a huge disadvantage.
Right. Yeah. And kind of to a different perspective to that question in terms of thinking about providers, medical providers, or folks who are working to provide this documentation to the courts. Is there advice that you would give to us in terms of how to make a case, I guess, for this client or for the survivor in terms of knowing that this may be used in multiple cases? So, for example, as a neuropsychologist, I might be asked to do a neuropsychological evaluation where I do have to outline, potential memory issues or whatnot, or maybe not, whatever their profile looks like. Do you have recommendations on what things we might need to think about or what we might want to consider in our language or our documentation to make sure it's the best case for our survivors?
What will really help that survivor is if it can be added either from the person doing the evaluation or from another person who could testify to say, here's the wraparound services that can compensate for that. If the person has memory loss, here are the treatment options that can help the person with that. And here's the prognosis of how we can make that better. And helping the court understand this, perhaps the memory loss isn't permanent. They actually can start to come back, and especially if they're getting treatment and if they're taking care of themselves physically, there's ways that we can minimize and we can teach them how, a kind of occupational therapy oriented, what are the things that we can do to help them compensate where there are losses in a way that it's, we can be sure that the kids aren't going to be at risk, in doing that. So I would say also, and right, that really depends on the roles. I know a person who's making a diagnosis isn't the person who's also writing out the treatment plan all of the time. But if the professionals can be thinking about how do we ensure that there's a treatment plan that can address the deficiencies that are being listed as a result of this injury, that will really help in the custody case.
Great. Thank you so much. Some more questions. We have a couple minutes left here.
Okay.
Another question. I've been told that judges in a desire to remain neutral and objective are rather hesitant to be trained on TBI. What are your thoughts on this?
Well, I guess my first thought is my impression is more they just don't know that they need the training. I think that they probably think if I need to know something, it's the attorney's job to bring that in. But once again, the normal person going through a divorce case can't afford to bring in expert witnesses on that. And so we do need the courts to have training and background in general on it, and then bring in the experts when you have a specific case that needs additional detail or information in order for them to figure out what is going on. But it changes everything. I'm old enough now that going back to domestic violence days, we used to not know what the harm was of domestic violence. And now judges get training on domestic violence and they have a much better understanding of the typical things that are seen. And so they can identify when somebody's saying X, they know, oh, but I know that these other things are probably also present. And so they're listening for that, right? And that's what we need to have happen. We need to get them more comfortable with understanding what's happening in these cases, especially when you're looking at the rates. Steffi in the session right before this one that was talking about what was it? 70% of the participants in it said their memory had been, showed that the memory had been affected by what happened there. And it's like, for the courts to understand, hey, when a brain injury happens, it's not just this might be a factor. This is going to be something they have to deal with. And here's how we can do that. And if they know that there are ways that you can put those wraparound services or protections around either the kids or the person who suffered the injury, that's going to make them feel a lot more confident in making a custody arrangement where the person who has had the injury is able to maintain custody of the kids.
Yeah, I think that's great in terms of thinking about, I know earlier in presentation, just kind of advocating for more education for lawyers, for judges. And I think that's a great call for all of us working in the field to break down those silos, right? Collaborate to reach across and try to share this knowledge and to work together to best serve these survivors. I
Yeah.
know we're at time, so I'm going to close this. I know there's another, I think, one more question in that we didn't get to in the chat, or a couple in there, but oh gosh, a bunch. So if you have the time, maybe to take a look at those. But such a great session. Thank you so much for all the information. Very, very important to think about as we're thinking about how to serve our clients holistically. So that wraps up this session. Thank you so much. And we'll return back here in about 4 minutes or so for the next session. Thanks again, Susan.
Thank you.